Welcome to iEnhance Advocate. iEnhance Advocate is a platform for lawyers having less than 5 years of practice to deliver a lecture on the topic of their choice. So, without wasting further time, I would like to give a brief glimpse about the speaker which we are having today. Our speaker today is Advocate Metanshu Purandare. Advocate Metanshu Purandare has worked with Special Public Prosecutor Ujjwal Nikam, Aniket Nikam, and Special Public Prosecutor Advocate Deepak Salvi for the CBI. So without further ado, I would like to call Advocate Metanshu Purandare to deliver his lecture on arrest and bail. Thank you.
Hello. Hello all, this is Advocate Metanshu Purandare. Thank you for the warm introduction. So today we are going to speak on the very interesting topic of arrest and bail. So what technically happens during the process which is laid down by law, that is what we are going to discuss at length today. I hope that I will keep you entertained throughout the entire lecture, and I do not wish to complicate it by saying something which is not even related to law. So I would be guiding you step by step as to what is the due process of law when it comes to arrest and bail. So initially I shall tell you that during the course of matter, whichever may it be as a complainant that you are getting as a criminal procedure, or whether it is a proper accused who has come to you as to seek bail, what is the minimum ground criteria that you are supposed to be following, that exactly we are going to discuss today. So essentially, let me just walk you through a certain provisions which are really important for us to know. So first of all, you are required to understand the kind of offences which are being laid down in the CRPC. First, which is more important and very essential to be known, is that you are required to understand the difference between a cognizable offence and a non-cognizable offence. So cognizable offence are the ones which are much more of a grievous nature, which much more introduces the aspect of how you are going to deal with when a cognizable offence occurs with you, if you are the complainant. If you have committed a cognizable crime, then what exactly would be the due process? So as a complainant, whenever I come across a cognizable serious kind of offence which is being committed before me or in front of me, then what is the due process that is to be followed? Very essentially, it is important to know that irrespective of wherever we go, wherever we are from, we first need to understand that where exactly are we standing. If we are standing as a complainant, we need to introduce all these aspects to a specific understanding that if we are acting as a complainant, we need to know a basic ground. First, do you know the accused? Yes, no. You do not know the accused, it's fine, no worries. Second, it is essential to be understood that when such a cognizable crime is being committed, such as the murder, or may it be even a grievous offence which is related to theft or rape, so during that point in time, what is the due process to be followed? Any accused whosoever is committing such a crime, you can get that person into the custody of the police. So now comes the point is that who can arrest? Three essential criteria which is important in understanding is that can you and me arrest? Is that an true question to be answered? Yes, you as an individual can very much arrest as an individual. Obviously, you can have the powers to detain and then submit the same accused person to the custody of the police. This is called as forwarding. Now in terms of understanding that when there is a magistrate being present and when there is a proper police officer being present जिसके सामने ये crime हो रहा है. Now in terms of understanding that whether a magistrate has the powers to arrest, is it true? Yes, no, let me make it very clear. The magistrate can himself arrest or direct the required police officer to go and arrest that particular individual. This is one. Second, you go to a police officer, you complain about that particular incident, and then the next moment the police officer does is that he goes and arrests that particular person. Now if he is known, obviously whatever is the due process that they will have to go and arrest that particular person. Now let's step from the complainant's shoe to the accused's shoe. Now, when we are understanding from that particular perspective, we need to understand that as a particular individual, when we are complainant, cognizable offences can be registered via a first information report. Now, what is a first information report? Any particular information which relates to the commission of a cognizable crime can be incorporated under an FIR. ये बार बार हम लोग जाते हैं ना, FIR लॉन्च करने जा रहा हो, FIR लॉन्च करने जा रहा हो. FIR is only lodged on a cognizable case, not on non-cognizable offences. Non-cognizable के लिए there is another provision which is under section 155 of the CRPC. Now, for example, if I am standing here and just now how I was being introduced with that person, in case I have a particular petty fight, as if I give him certain kind of a blow on his face, but he is not that temporarily injured, or he is not facing any particular, or forget that also, if I give him a particular bad words, so during that point in time, would it be a cognizable offence or would it be a non-cognizable offence? Very important to understand. The description and the differentiation is given well versed according to the Indian Penal Code. CRPC and the IPC go hand in hand. There cannot be any particular perspective in understanding कि कौन सा offence कब commit हुआ, उसका imprisonment क्या है. So we need to first understand whether these particular giving such as bad words, or in terms of understanding that what is the particular individuality that is to be understood. So what are we going to follow during that point in time? If it is a non-cognizable offence, you go to a magistrate, you mention all the incident that has happened, and then the magistrate will remove an order for the arrest of that particular person. Now let us understand that whether giving bad words fall under the jurisdiction of the IPC. Technically speaking, yes and no both. It depends from the facts and the circumstances, as well as the facts which have been happened with that particular complainant as a victim during that point in time. Now the question is whether the complainant knows the other person. Obviously, if you know the other person, it is more than easy to suggest that particular person to the police and then get that person arrested. But what if you are not aware that who is technically that? Now the other day I had gone through a particular incident of one of my building society members who had gone to purchase vegetables in the morning. So somewhere around 9 o'clock AM or so, I was being I just received a call, and then I was like I was informed that few people had snatched her chain and bangles and all that she was wearing, and phone and everything got stolen. So during that point in time, what may have been the due course of process that we need to be followed? So you happen to get such calls during that point in time, and as a lawyer, it is upon our duty and discretion to provide the right aid. So understanding from that particular perspective, we are also required to understand that during this course of investigation, you are first supposed to dial nothing but 100 through anybody's phone. It is not necessary that it has to be through the complainant's phone only. So the very much essential background of a cognizable crime being committed. Now theft is also a cognizable crime. So in terms of understanding theft and robbery, we would be required to first understand that an FIR has to be lodged. Now the understanding of cognizable and non-cognizable, which I am very sure that you must have got a little bit of idea, if not everything as a whole. Subsequently, there is another kind of offence. Now cognizable and non-cognizable offence to ho gaya. The other part is bailable and non-bailable offences. Now when we speak technically about bailable and non-bailable offences, what are they technically, and how are we going to distinguish each of them from a particular understanding? Now in the Indian Penal Code, after every particular section, you will see a classification of offence that gives you an idea whether that particular offence is of cognizable nature, non-cognizable nature, is it bailable or non-bailable. So I keep telling everybody throughout now and then that which particular cases fall under the ambit of bailable offences and which do not fall under the non-bailable offence. Now recently there is a particular issue that we all may be facing somewhere down the lane, such as you try to override a particular signal which you are while you are driving, and then you have been stopped. You come out of the car, You say something, you're like, when I crossed, it was already green, it was turning yellow, may have turned red, so I have no idea. And in case any police officers threatens you by saying that, boss, I have the right to apply section 353, so we need to understand that these particular offences are again demanding to the extent of being called as a cognizable as well as non-bailable offences. Now, why are the public servants being given this particular authority? Is because of the simple reason that this particular person is a public official, he is a public servant, and it is also required in terms of understanding that this particular person also demands for a particular extension. Now, extension not in terms of any other benefit, but in terms of the security of his right. So, in order to protect the rights of every public servant, section 353 of the Indian Penal Code is very much considered under the ambit of cognizability, and it is considered under the understanding of the what we say as the non-bailable offences criteria. Now, let us understand that if it is a bailable offence, non-bailable offence, such as if some particular accused commits a crime of a particular individual, so what exactly are you going to follow? So, the moment you are being arrested, now let's step from the shoes of a complainant to the shoes of the accused. Now, when we are understanding that when we become an accused, what are the rights of an accused? First, very simply, now there are various precedents such as the DK Basu versus State of Bengal and all these other cases which merely reflects upon the rights of an accused during detention and arrest. These are the particular rights which are being laid down. There are several such rights which are being incorporated, out of which is more necessary is that right to have an access to a lawyer. This is the most important criteria of an accused to get a proper legal guidance. So, which is why that particular right is always present. Now, let me tell you that once you are taken into custody for a particular commission of a cognizable crime, you would be required in terms of understanding that these particular criteria of arrest demand a various kind of criteria. Now, what are those criteria? Cognizable crime committed, you go arrest that particular individual. Within 24 hours, you are required to be produced before a magistrate. Now, that magistrate has powers to, first, if it comes within his jurisdiction, he may give two options. First, he has two options technically. First is judicial custody and the other one is the police custody, which is obviously there in remand matters. So, during that point in time, what happens is the police custody is being demanded by the prosecution, and you as a lawyer for your accused, you would be demanding for a judicial custody. Now, what happens is the PP says that, okay, boss, during the entire course of for the course of investigation and understanding in depth, we would be requiring a proper police custody for investigation purpose. So, technically the police custody can be given a maximum of 15 days and minimum of whatever days until 15 days could be considered. But in terms of understanding that these particular offences are being laid down to a particular understanding, such particular thing has been now a very important case that happened with Anil Deshmukh versus State of Maharashtra, is that police custody and the judicial custody, that was a much more debated one, and wherein a particular judicial custody was remanded back to police custody, and it was essentially to be done for the course of investigation. This had temporarily been the essential criteria in terms of understanding that how we are stepping towards the course of investigation. Now, the police custody is so far as for the police, that the police will have to be taking you in terms of understanding that you are in the custody of the police and the interrogation will take place on you. Say suppose the magistrate says for the next 5 days you will be in the police custody. Next date you have been presented before the court, you have been given either a police custody or judicial custody at the exercise of the discretion of the magistrate. In case the magistrate feels that no, there must be a particular ingredient that needs to be covered for the course of investigation, you would be sent back to the police custody. If the investigation and the interrogation, not the investigation rather, just the interrogation has been completed, for the recording of the statements, then during that point in time you are sent back to the police custody. Then during that point in time, you cannot, obviously when you're in PC, you cannot apply for a bail. You will get bail only during the course of judicial custody. So now let us understand that whenever there is such an ambit of understanding, that who has the matters to, who has the powers to understand the basic matter of right. So let me first tell you, according to section 28 and 29 of the CRPC, section 28 is about the powers of a sessions judge, section 29 is the powers of the magistrate, CJM, JMFC and JMSC. Now what are these three important parts that I am going to speak about? So when I am speaking about the chief judicial magistrate can pass any order which is which can be related to the only imprisonment, and it cannot exceed except in the cases of death and life imprisonment. Now coming to the JMFC has powers to only distinguish between 3 years maximum imprisonment and 10,000 rupees fine. Subsequently, if it is a particular process of understanding that this particular individual needs to be tried by a judicial magistrate second class, so the judicial magistrate second class has powers to try only for a particular punishment which is nearly about 1 year, and not a particular fine exceeding 5,000 rupees can be imposed by a judicial magistrate. Now coming towards the sessions judge. Now sessions judge and the additional sessions judge have the same power. Now the sessions judge and the additional sessions judge can pass any sentence with regards to the life imprisonment and death, but it needs to be confirmed by the way of the High Court. Subsequently, you would be required in terms of understanding that an assistant sessions judge has powers to not even consider during that point in time any sentence which is with regards to, which is very similar and synonymous to the criteria and the punishment laid down by the chief judicial magistrate. So technically both of them have equal powers and are in equal strata. Now coming to the topic of bail, during that point in time, first we need to distinguish that during the course of investigation how a particular offence has to be distinguished. So who will be the first person that you will be presented before? You would be presented before in terms of understanding that during this course of investigation you would be required to move in a bail application the moment you are sent to the judicial custody. Now the moment you are sent to the judicial custody, is that a win for any advocate? Technically yes, but technically no also. Now there is no such confirmation that after judicial custody for sure you are going to get the entire criteria of bail, मतलब bail तो हो ही जाएगा, ऐसा नहीं होता. So during the entire understanding you are required to understand that section 167 subsection 2 and subsection 1 speaks explicitly about the time period of any course of investigation. Now let us understand that how does this provision work. In case any particular offence which is about life imprisonment and death, so during that point in time the police gets nearly 90 days from the hold of the accused. So that is the duration of investigation that is being given, and then additionally 30 days ka time period can be extended via the permission of the court. Now what in the case of 7 years and 10 years imprisonment, for that how are we going to understand? So for them it is specifically said that for 7 years of imprisonment you need nearly about 60 days to complete an investigation. Obviously the 30 days time period is always there to increase the time duration for the course of investigation. So in terms of understanding, when do you move a bail application? So now bail applications are of preliminary 3 types, which is called as the regular bail, which is under section 436. 437 is about non-bailable offences, and third, which is also important, is the anticipatory bail. So most of my fellow students and colleagues get confused often as to which are the criteria for which bailable offences can be considered, which section does it come. So let me clear the clutter here. No other person should ask me after this course of interview, that how are we going to, after this course of lecture, that how are we going to continue with this entire process. So first and foremost, it is important that for non-regular bailable offences, non-bailable offences, you are required to invoke the provisions of section 437. Subsequently, you will be required to go ahead and push yourself towards any particular bailable offences being committed, then section 436 of the CRPC. Now, what happens is, most of the times you get a particular call from the police. Okay, now I am speaking about anticipatory bail. When can you get it? Suppose you have an idea that, yeah, perhaps I may have committed a particular cognizable offence, intentionally or not intentionally. Mens rea and actus rea is another question that comes into mind. But before that, let us understand that in case you are a particular person who thinks that perhaps you may have committed a particular cognizable, or intention is the necessary criteria which has been proved during the course of trial, that has not been examined in the preliminary stage. So in terms of understanding that if you are a particular person who is being incorporated for a particular cognizable crime and you have received a phone call from the police station stating that, boss, you need to come to the police station and record your statement. Now, first it is important that you get the entire information as to what are being the charges levied upon you. In case an FIR has been lodged, so during that point in time you have all the right to get an access of the FIR. Now, what happens is, in most of the cases of the FIR, you are not being named in the FIR at all, but just of suspicion you are being sent out a particular notice. So anytime you receive a call, you need to first tell them that you first give me a particular piece of note, which is a notice under section 41A of the CRPC, which gives me a right to be presented before you and narrate all my grievances before you and state all the true facts before you. Subsequently, you are required to comply with, as an accused, you would be requiring to comply with it. In case you are so sure that you have committed that particular offence and you are technically, in terms of understanding that these particular offences are required, that you will be taking to an immediate arrest, the moment that you are supposed to do is that you are supposed to file an anticipatory bail application from the day of the receipt of the notice. Now the question is, सब फटफट हो गया, अरेस्ट हो गया, अरेस्ट करने आ गए, अभी मैं क्या करूँ? अभी अरेस्ट करने आ गए तो मैं क्या करूँ? Is the time when you are to cooperate with the police then and there itself. You are supposed to state out the straight out facts, whatever it is, in an open idea, by seeking a proper legal advice. Do not fall under the trap of stating something which is in excess or below the excess of the advice of your advocate, because that turns out to the spoiling of the case. Now, in terms of understanding that these particular advices, whichsoever may be, we will be required in terms of understanding that any particular offence which has been, you've been sent out a notice for, you would be required for, going before the police authorities, investigate, cooperate with the investigation, record your statement, come back. So, does that mean can you file for an anticipatory bail application then? Technically, until and unless nothing comes to you, you are not required to file for an anticipatory bail application. In case you have an idea that maybe you may have created that particular cognizable commission of crime, so you are entitled right from the receipt of that particular notice to go and seek for an anticipatory bail. So, are we technically accepting that particular crime? Yes, that is a particular misnomer which I choose not to answer. But again, you are required to do so. Now, what if you are a particular accused who has been presented after 24 hours before the judicial magistrate? So, does that mean that you are in illegal custody? Technically, yes. You can file for a writ petition of habeas corpus before the High Court and get your rights solved then and there itself. But in case, if it is of such nature that the police have already taken the permission and it is during that point in time that the magistrate has directed to be presented not before you but before some other particular magistrate. So during that point in time, the court record speaks for itself. So remember when we were studying tort, there was a particular legal maxim which was res ipsa loquitur. So that particular offense is very much, that particular maxim is very much in technicality that needs to be followed. So the question is that if you are a particular person who is worried that you may get arrest, anticipatory bail application can be filed. Whether it will succeed or no is the question of law and not of fact. So let me remind you, whatsoever your particular grounds are, you need to be very much sure about your grounds, and then technically state what all, if the magistrate or the sessions judge feels that during that point in time you are a particular right person to get this benefit of doubt, then you may be given a particular bail during that point in time. So technically speaking and summing up the entire thing, yes, you are a particular person who may have been seen a cognizable crime. If we have seen from the perspective of being an accused, we have seen from the perspective of what our rights are. As a lawyer, what is the true essential criteria? But we did not speak about one essential part as a complainant. What if you go to the police and the police denies that I am not going to register your complaint? So what is the essential requirement that you are required to fulfill? Are you required to argue with the police officer? Let me tell you, do not fall under the trap of arguing with the police officer by yourself. Do not ever cross your limits as a accused. You are required, or not also as an accused, but also as a complainant. You also have a particular remedy which can be sorted. Now what is that particular remedy? Let's talk at length. In terms of understanding that in case there is a cognizable crime which has been committed and you are going to the police officer and he says that, boss, no, I am not going to register an affair. Next moment, what should we do? Next moment, you are supposed to go to the DCP. Now what does the DCP do in case he also does not respond or something like that, or if he responds that this is not a cognizable crime? Then what are the remedies that you have got? Now you move to the magistrate. Now there are two essential criteria in terms of understanding. First is a mode of private complaint and the other one is through registering an FIR. Now how do you get the magistrate, how do you go before the magistrate and get your FIR registered? Very simple. You go before the magistrate, submit an application for section 156 subsection 3 and directing that particular police station to register the FIR. Yes, this can be corporated. One. Second is the means of private complaint. Now what happens in the private complaint? Section 199, 200, 201, all these particular processes of the CRPC are the particular requirement of right from section 198 to 201. You will get your answers right there in the CRPC. So yes, you can go and demand for a particular right that has to be constituted. You as a complainant, you as an accused have rights. Do not feel that just because you have committed a crime you have lost your rights. You still have your rights. Learn to protect your rights and do not fall under the trap of arguing with any particular police officers. Number one, I am not going to suggest that a particular person that just because he is a police officer you are required to maintain a decorum. Not because of that. I do not fear anything else. I fear only one particular essential part. And again I am highlighting section 353 of the IPC is still a danger for most of the public and the social workers and all these other things, which I rest not fall under the trap of mentioning any controversial statements. But again, section 153 of the CRPC, section 353 of the IPC, it is essential in terms of understanding that this particular law is such that it can get you into trouble and you can be prosecuted for the same. Again, let me remind you, it is a cognizable crime and it is a non-bailable offence. So yes, you will be having a tough time in moving section 437 of the CRPC for non-bailable offences. So for anticipatory bail, which section is it? It is section 438. Now what in case of POXO cases? What happens during that point in time? For that, any particular special courts, special acts whichever are being enshrined, we are required in terms of understanding that section 439 of the CRPC के अंतर्गत आप आपके जाके बेल के लिए एप्लीकेशन मूव कर सकते हैं. ज़रूरी नहीं है कि आपको मिलेगा या नहीं मिलेगा, ठीक है. That is upon if the discretion of the judges is such that yes, benefit of doubt can be levied upon that particular accused, then that particular person can be given the suggestion of such particular bail. So that's all for now, and thank you so much, and thank you.
Metanshu, thank you. It was nice listening to basically an entire overview of CRPC, arrest, bail. So thanks for giving nice information and nice knowledge to people.
Thank you, sir.
Now this is a small token from Hammurabi
Thank you, sir.
for you. Thank you.
Thank you, sir.